The first thing I heard was the scrape. It was a sound that had no business existing at 6:42 in the morning, not the gentle whisper of the newspaper hitting the driveway, nor the chirping of the finches that had taken up residence in the eaves of my porch. This was a harsh metallic grating. Shovel against concrete. It was a sound of deliberate, unwelcome labor. I set my coffee mug down on the kitchen counter, the ceramic making a soft click against the granite. The mug was a simple white one, a gift from my late wife Eleanor. On its side, in her elegant script, it said, "The measure of a man." I had always thought it was a bit grandiose, but I used it every morning. It was a small, tangible piece of her that remained. I walked to the bay window in the living room that overlooked my front lawn. The sun was just beginning to slice through the morning haze, casting long, distorted shadows across the perfectly manicured St. Augustine grass, and there she was, Carol, president of the Evergreen Terrace Homeowners Association, self-appointed queen of our quiet suburban fiefdom. She was a woman who moved through the world as if it were a slightly disappointing hotel she was begrudgingly tasked with managing. Dressed in what I suppose was her idea of work attire, Lululemon leggings, a bright pink visor, and brand new gardening gloves that looked like they had never touched actual soil. She was directing 2 day laborers. One of them was the source of the noise, using a spade to pry up the edge of the sod where my lawn met the sidewalk. The other was carving a shallow, but undeniably present, trench across the corner of my property. I watched for a moment, my mind a placid lake of disbelief. They were digging. On my land. The purpose was immediately obvious to my engineer's eye. The common area across the narrow street, a small, grassy island, at the entrance to our cul-de-sac, had a tendency to pool water after a heavy rain. For years, the HOA's solution had been to periodically run a sump pump, draining it into the storm sewer down the block. A clumsy, but effective fix. What Carol was orchestrating now was a new, cheaper solution, a gravity-fed drainage channel, a ditch, and she was routing it directly across the corner of my lawn, aiming for the gutter that ran along my property. She was solving her water problem by making it my water problem. I picked up my phone from the side table, opened the camera application, and pressed record. I didn't move from the window. I just stood there, a silent sentinel in my own home, documenting the transgression. The phone's microphone was sensitive enough to pick up her voice, sharp and imperious, cutting through the morning air. She was pointing, gesturing, instructing the men to make the trench deeper to ensure a positive flow. She used technical terms she clearly didn't understand, like a child mimicking a parent. After a few minutes of this, I decided the passive observation phase was complete. I walked back to the kitchen, topped off my mug, and went out the front door, leaving it slightly ajar. I didn't slam it. I didn't run. I walked at my usual, unhurried pace down the driveway, the warm, damp air of the Florida morning clinging to me. I stopped at the edge of my lawn, a few feet from the man with the shovel. The air smelled of cut grass and freshly turned earth. Carol saw me, and her face, already set in a mask of intense concentration, hardened further. She marched toward me, her arms crossed, her visor casting a pinkish shadow over her eyes. "Arthur," she said, her voice dripping with condescension. "Good morning. We're just doing a little bit of necessary community maintenance. This pooling has been an issue for years, and the board has finally approved a permanent solution." I took a slow sip of my coffee. I looked from her face to the man who had stopped digging and was now leaning on his shovel, watching us. I looked at the ugly brown scar he was carving into my lawn. "Carol," I said, my voice even and low, "you are on my property, and you are digging a trench on my property. I need you and your workers to stop, fill in what you've dug, and leave." She actually laughed. It was a short, sharp bark of a sound. "Don't be ridiculous, Arthur. This is an HOA-approved project. It's for the good of the community. No, we have an easement. It's historic use. People have been walking across this corner for years." I didn't blink. My phone was still in my hand, held loosely at my side, the lens pointed directly at her. There is no drainage easement on my property, Carol. Not for historic use or any other reason. You are trespassing. Your workers are causing criminal damage to my property. I am asking you one more time, politely, to stop. Her smile vanished. The performance of neighborly concern was over, replaced by the tyrant she kept just beneath the surface. Listen to me, she hissed, taking a step closer. I am the president of this HOA. The board voted. This is happening. If you interfere, I will have you fined for obstruction of HOA business. I will put a lien on your house so fast, your head will spin. I will call the sheriff's department and have you removed for harassing my workers. Do you understand me? I raised my coffee mug and took another sip. I said nothing. I just looked at her. I looked at the conviction in her eyes, the absolute, unshakable belief in her own authority. The belief that her will, once expressed, became law. The belief that rules were for other people, and that documents, deeds, and laws were mere suggestions to be ignored if they proved inconvenient. I held her gaze for a full 10 seconds. Then, I simply turned around and walked back into my house, closing the door softly behind me. I went to the kitchen, placed my mug in the sink, and walked to my office. I sat down at my old wooden desk, the surface worn smooth by decades of work. I could still hear the scrape of the shovel outside. She had no idea. She had no idea who I was, what I did for 45 years. She had no idea that her little performance, her threats, her baseless claims of authority had all just been entered into evidence. She had no idea that by digging a 3-inch trench, she had just opened a chasm that was about to swallow her whole. But before I tell you what I did next, I should probably explain. This wasn't the beginning. This was simply the moment the quiet war became loud. It had been brewing for 3 years, ever since Carol took over the HOA, and I, in my own quiet way, had been preparing for this day for just as long. I am a retired civil engineer. Specifically, my entire professional life was spent in the field of land development and water management. For 45 years, I designed subdivisions like this one. I wrote the legal descriptions for deeds. I plotted easements. I calculated stormwater runoff and designed drainage systems that complied with county, state, and federal regulations. I was one of the people who wrote the very rules that governed the ground beneath our feet. I spent my days in a world of documents, of plats and surveys, of covenants and restrictions. A world where things were either true on paper or they were not true at all. My wife Eleanor used to joke that I loved a well-drawn plat map more than a sunset. She wasn't entirely wrong. A sunset was beautiful but fleeting. A plat map, recorded and filed with the county clerk, was a form of permanence. It was order. We bought this house 20 years ago. We were the second owners. It was a corner lot which I liked. More light, more space. I pulled the original subdivision plat from the county records before we even made an offer. And I walked the property lines myself, using the original survey markers, iron rods I located with a magnetic detector, as my guide. I knew every inch of that land, legally speaking. I knew its encumbrances and its rights. I knew, for instance, that there was a 5-foot utility easement running along the back of the property for the power lines. But the front corner, the one Carol was currently excavating, was completely unencumbered. It was mine, free and clear. Eleanor had loved the house for the garden. I loved it for its clean lines on a map. We had been happy here. After she passed 5 years ago, the house became my sanctuary, a quiet, orderly place in a world that felt increasingly chaotic. I maintained it, I cared for it, and I expected its boundaries to be respected. Carol and her husband Frank had been the original developers of the neighborhood 30 years prior. Frank was a brash, cut-corners kind of developer, but he knew enough to hire competent people, like the engineering firm I used to work for, to make sure his projects were legally sound. He had passed away about 4 years ago, leaving Carol with a lot of money and a profound sense of boredom. She decided to fill that void by seizing control of the HOA. Her campaign for president was a masterclass in populist demagoguery. She promised to restore property values and enforce the standards that make Evergreen Terrace special. What that meant, in practice, was a reign of petty tyranny. She started small, a flurry of violation notices. Mr. Henderson at number 12 was fined $50 because his recycling bin was visible from the street 2 hours before the designated time. The Patels at number 8 were fined $100 because the swing set they had installed for their grandchildren was made of cedar, not the board-approved pressure-treated pine. Every notice was written in the same aggressive, condescending tone, citing bylaws that were either misinterpreted or, in some cases, entirely fabricated. Most people, being conflict-averse and busy with their own lives, just paid. It was easier than fighting. They grumbled, they complained to each other over the fence, but they wrote the checks. I received my first notice about 2.5 years ago. It was for improper lawn maintenance. The supposed violation? I had a small patch of clover near the oak tree. Carol's letter, complete with a blurry photograph, declared it a noxious weed and demanded its immediate removal, along with a $25 fine. I knew the HOA covenants chapter and verse. I had a copy. There was no mention of clover. There was a general clause about keeping lawns in a neat and tidy condition, but nothing that specific. I could have fought it. I could have written a letter, cited the documents, demanded a hearing. But I didn't. I did something else. I went to my desk, wrote a check for $25, and mailed it to the HOA. When the canceled check came back with my bank statement, I scanned it. Then, I created a new folder on my computer's hard drive. I labeled it HOA. Inside, I created a subfolder labeled Fines. I saved the scan of the check and a scan of the original violation notice. 2 months later, I got another one. This time, it was for my mailbox. Apparently, the black paint was faded and needed to be refreshed with HOA-approved semi-gloss black. Another $25 fine. I went to the hardware store, I bought a can of paint, I kept the receipt, I painted the mailbox, and I sent another check. And I scanned the receipt, the notice, and the canceled check, and filed them away. I kept the receipts. It became a quiet mantra. Every interaction, every piece of paper that flowed from her office was preserved. On paper, I was a compliant homeowner. In reality, I was building a case. I was an archivist of her overreach. The folder on my computer grew. It was a meticulous, cross-referenced library of her abuses, not just against me, but against others. When Mr. Henderson mentioned his recycling bin fine, I asked him if he still had the notice. He did. He emailed me a copy. I filed it away in a subfolder labeled Henderson. When the Patels were forced to tear down their swing set, I took a picture of the disassembled cedar planks lying by their curb for bulk trash pickup. I saved it. The physical manifestation of this was a simple, beige manila folder I kept in the bottom drawer of my desk. It was labeled, simply, Carol. Inside were the originals, the letters with her signature, the receipts, the printouts of emails. It was getting thick. It was my insurance policy. I hoped I would never have to use it. I valued my peace and quiet above all else. But I was also a man who believed in order. And Carol was a force of chaos, draped in the guise of order. Her actions this morning, the physical invasion of my property, had just activated that insurance policy. She had no idea. So I sat at my desk, and I got to work. The first step was formal notification. Arguing with her in the yard was theater. What mattered was what was on paper. I typed up a formal cease and desist letter. It was simple, direct, and legally precise. It cited the legal description of my property from my deed, specifically noting the lack of any recorded drainage easement. It referenced the Florida statutes regarding trespassing and property damage. It demanded an immediate cessation of all work, the restoration of my property to its original condition, and a written assurance that no further attempts would be made. I printed 2 copies, One for my records. One for her. I drove to the post office and sent it via certified mail, with a return receipt requested. This was critical. The green return receipt card, when it came back with her signature on it, would be irrefutable proof that she had received the warning. It would transform her actions from a potential misunderstanding into a willful and knowing violation. It cost me $7.50. I kept the receipt. While I was out, I also stopped by a copy shop and printed a large 24 by 36-inch copy of the relevant section of the subdivision plat map. The lines were crisp and clear. Lot 14, my lot, was outlined in yellow highlighter. The common area, Lot A, was in green. There were utility easements marked with dashed lines at the rear of the properties, but the front corner of my lot was pristine, untouched by any such encumbrance. When I got home, the workers were gone, but the trench remained. A muddy wound in the green expanse of my lawn. Carol's pickup truck was gone from her driveway. I suspected she had taken the rest of the day off to celebrate her victory. I taped the large plat map to the inside of my front window, the highlighted section facing out. It was a silent, public statement, a declaration of fact. The certified letter was delivered the next afternoon. My security camera, a small, discreet dome I'd installed after a few neighborhood kids started cutting through my backyard, captured the mail carrier walking up to her door. It captured Carol answering, signing the green card, taking the envelope and closing the door. A few minutes later, her front door opened again. The camera recorded her walking to a recycling bin, the white certified mail envelope still in her hand, and dropping it in. She hadn't even opened it. She had dismissed a legal warning as if it were junk mail. I saved the video file. I labeled it Certified Letter Delivery and Discard. The evidence folder grew thicker. This was the turning point. This was no longer a disagreement. It was a deliberate act of defiance against documented fact. She was telling me in the clearest possible terms that the law did not apply to her. That was a mistake, because now I was no longer just a homeowner protecting his property. I was an engineer with a problem to solve. I retreated to my home office. It was my sanctuary, a room filled with the ghosts of my professional life. Bookshelves groaned under the weight of engineering manuals, zoning codes, and legal treatises on property law. My old drafting table, its surface covered in nicks and cuts from decades of use, stood in the corner. This was where I was most comfortable. I spent the next 2 days in that room. I didn't just review my own file. I went deeper. I went back to the very beginning. I contacted a young man named David, a licensed surveyor whose father I had worked with for years. I explained the situation. I didn't need him to find the property line. I already knew where it was. I needed him to come out with his official equipment and produce a new, legally binding survey map that would stand up in court. I needed a fresh, unassailable document. He agreed to come the following Monday. Next, I went online to the county's public records database. I spent hours sifting through digital archives. I pulled every document related to the Evergreen Terrace subdivision. The original development plan, submitted by Frank. The permits issued by the county. The minutes from the county commission meetings, where the project was approved. And that's when I found it, the bombshell. It was in the notes for the final stormwater management permit, issued in 1988. The county engineer at the time had flagged the exact issue of drainage from the common area island, Lot A. The permit was granted contingent on the developer, Frank's company, constructing and maintaining a subterranean drainage pipe running from Lot A under the street and connecting directly to the main storm sewer at the far end of the cul-de-sac. It was a specific, legally binding condition of the development's approval. Frank had built it. I knew he had because I could see the manhole cover for the storm sewer connection right where the plan said it should be. Carol wasn't just violating my property rights. She was violating the original, foundational permit for the entire subdivision. Her cheap, surface-level fix was a direct contravention of the engineered solution her own husband had been legally required to build, and that the HOA was legally required to maintain. The reason the common area was pooling water wasn't because of a design flaw, it was because the HOA, under her leadership, had failed to perform the routine maintenance on the underground pipe. It was likely clogged with years of silt and debris. Her solution, digging a trench on my lawn, was an attempt to cover up her own negligence. She had no idea she was creating a paper trail that led directly back to her own failure as a manager. But that wasn't the biggest discovery. As I was looking through the HOA's filings, something seemed off. I switched from the county site to the state's Division of Corporations database. Every HOA in Florida is a corporation, typically a nonprofit, and they are required to file an annual report and pay a small fee to remain in active status. It's a basic administrative task. I searched for Evergreen Terrace Homeowners Association Inc. The result came up instantly, and next to the name in bright red letters was the word inactive. My breath caught. I clicked for details. The corporation had been administratively dissolved by the state 2 years ago for failure to file its annual report. All of its powers, all of its authority, were legally suspended. For 2 years, Carol had been presiding over a ghost entity. Every fine she had levied, every violation she had issued, every board meeting she had run, had been done without any legal authority whatsoever. The checks I and my neighbors had written had been deposited into the bank account of a defunct corporation. She wasn't just a petty tyrant. She was, legally speaking, a fraud. I sat back in my chair, the leather creaking in the quiet room. This was it. This was the key. This wasn't just about a trench in my yard anymore. This was about the fundamental legitimacy of her entire reign. I methodically downloaded every relevant document. The permit, the county meeting minutes, the screenshot of the inactive corporate status. I saved them all to a new folder. I labeled it The Bombshell. On Monday morning, David the surveyor arrived precisely at 8 o'clock. His truck was clean. His equipment looked new. He was professional and efficient. We exchanged a few pleasantries, and I handed him a copy of the original plat and my deed. Just confirm the original markers and stake the line along the front, especially that northeast corner, I told him. As he began setting up his tripod and total station, a sophisticated electronic surveying instrument, Carol emerged from her house. She saw the truck. She saw the equipment, and a predictable storm of fury gathered on her face. She marched across the street, her hands on her hips. "What is the meaning of this?" she demanded, not of me, but of David. "You are on HOA property. You do not have permission to conduct a survey here." David, to his credit, was unfazed, and he glanced at me. I gave a slight nod. "Ma'am," he said politely, "I am a state-licensed surveyor retained by the owner of this property, Mr. Miller, to confirm his property boundaries. I am operating under his legal authority." "He has no authority," she shrieked. "This is a common area. I am the president of the HOA, and I am ordering you to stop immediately." This was the moment she had threatened, the call to the authorities. She pulled out her phone and stabbed at the screen. "I am calling the sheriff. We'll see who has authority then. You're going to be arrested for trespassing." "I'll wait," I said quietly. I gestured for David to continue his work. He hesitated for a second, then, seeing my calm, turned back to his instrument. 20 minutes later, a sheriff's cruiser rolled quietly up the street. A deputy stepped out, a young man with a calm, professional demeanor. His name tag read Miller. No relation, but the irony was not lost on me. Carol practically ran to him, launching into a breathless, dramatic performance. "Officer, thank God you're here. This man, she said, pointing at me, is trying to steal community property. He's hired this person to illegally move the property lines. He's been harassing me for days. He's unstable. I'm afraid of what he might do." The deputy listened patiently, his expression unreadable, and he let her finish her entire tirade. When she finally wound down, He turned to me. Sir, can I get your side of the story? I didn't raise my voice, I didn't gesticulate. I simply held up the folder I had brought outside with me. Deputy, I began. My name is Arthur Miller. I am the owner of this property, at this address. This woman, Carol Peterson, is the president of a local homeowners association. This morning, she has been interfering with a lawful survey of my property that I have commissioned. The survey is being conducted by this man, David Chen, who is a licensed surveyor in the state of Florida. I opened the folder. I didn't pull out the whole arsenal. That wasn't necessary yet. I just pulled out one document, a clean copy of my warranty deed. This is the deed to my property, recorded with the county, I said, handing it to him. It describes the legal boundaries. There is no easement on the corner in question. A few days ago, Mr. Peterson hired workers to come onto my land and dig a trench. I have video of this. I sent her a formal, certified letter demanding she cease, which she ignored. I have proof of delivery. Now I am simply having my property line professionally marked to prevent any further encroachment. She is the one trespassing and causing a disturbance. The deputy took the deed. He read it. He looked at the clear legal description. He looked at the raised seal from the county clerk. This was a real document. He looked over at Carol, who stood there empty-handed, her entire case built on bluster and a title. Ma'am, the deputy said, turning back to her, do you have a copy of the HOA documents or a recorded easement that grants you the right to alter this gentleman's property? Carol sputtered. It's in the bylaws, it's historic use, everyone knows. I need to see a document, ma'am, the deputy said, his tone still patient, but with a new edge of firmness. Right now, this appears to be a civil matter. However, this man has a right to have his property surveyed. If you continue to interfere with the surveyor or harass the homeowner, you could be the one facing charges. I suggest you step back onto the common area and allow them to complete their work. Her face was a mask of pure indignation. She had called the law to bend to her will, and the law had just politely told her she was wrong. She shot me a look of pure venom. This isn't over, Arthur, she muttered, just loud enough for the deputy and me to hear. I'll be sure to note your threat in my report, ma'am, the deputy said coolly. He then turned to me. Sir, would you like to make a formal statement about her threats and the interference? Yes, I would, I said. I would like it on the record that Carol Peterson, after being shown proof of my property boundaries, threatened me by saying, this isn't over. I perceive that as a threat of future harassment or retaliation. The deputy nodded, taking out his notepad. Noted. His body camera, I knew, had captured the entire exchange. The audio, the video, her baseless accusations, my calm presentation of fact. It was all evidence now. Another layer in the file. Carol, defeated and humiliated, stormed back to her house, slamming the door behind her. The deputy gave me back my deed, wished me a good day, and left. The street was quiet again. David the surveyor, who had been wisely silent during the whole affair, let out a low whistle. Wow, he said, she's really something. You have no idea, I replied. I watched as he finished his work, hammering in wooden stakes with bright orange flags, marking the line with undeniable clarity. One stake stood right in the middle of the half-dug trench, a bright orange flag of defiance. The confrontation with the sheriff's deputy was a public event. Small, but public, and it had been witnessed. Later that evening, as I was watering the azaleas by my porch, my neighbor from 2 doors down, Mr. Henderson, approached me. He was a quiet, retired accountant, a man who had lived in the neighborhood even longer than I had. He was one of Carol's favorite targets, constantly being fined for the most trivial things. He walked with a nervous energy, constantly glancing over his shoulder toward Carol's house. Arthur, he said, his voice barely a whisper, I saw what happened this morning. With the sheriff. Good for you, for standing up to her. It was a necessary step, Bill, I said. He fidgeted with the brim of his gardening hat. Listen, he said, leaning closer. There's something you should know, something that might help. He pulled a small, cheap-looking USB thumb drive from his pocket. For the past year, I've been recording the audio of the HOA board meetings on my phone. She doesn't allow anyone to record, but I just put my phone on the table and pretend I'm texting. She said things that show she knows she's breaking the rules. My heart beat a little faster. This was the voice of the community, the corroboration from a fellow victim. What kind of things, Bill? Things like, he said, lowering his voice even more. The covenants are just guidelines. What I say goes, and we don't need to spend money on a lawyer to interpret things. I know what the founders intended. She said that when the board questioned her about getting a legal opinion on a new fine schedule. It's all on here. He pressed the thumb drive into my hand. I was afraid to do anything with it, but you know what to do, just don't tell her it came from me. I won't, Bill, I promise, I said, closing my hand around the small piece of plastic. Thank you. This is more helpful than you can imagine. He nodded, gave a weak smile, and scurried back to his own yard. I went inside and plugged the drive into my computer. It contained a dozen audio files. I spent the next hour listening. It was even better than he'd described. Carol's voice, arrogant and dismissive, caught on tape, explicitly stating her intent to ignore the governing documents. It was a prosecutor's dream. I copied the files into my bombshell folder. The next day, I received an email. The sender was Sarah Jenkins, the HOA treasurer. She was a younger woman, a CPA, who had been elected to the board before Carol's presidency and had been trapped there, increasingly disillusioned. The subject line was confidential. The email was brief. Arthur, I heard about the incident with the sheriff. I can't say much in writing, but Carol has been using the HOA's operating account to pay her personal attorney for actions related to you and other homeowners. This is not a board-approved expense. I have the bank statements and the lawyer's invoices. I believe this constitutes misappropriation of funds. If there is a formal investigation, I am willing to cooperate. The coalition was forming, the fearful ally and the disillusioned insider. The pieces were moving into place, drawn to the gravity of documented fact. Carol's power was based on social pressure and isolation. By standing firm, I had become a rallying point. People were no longer afraid. I knew Carol's next move would be one of desperation. When a cornered animal is faced with a threat it cannot intimidate, it lashes out with everything it has. Her final escalation came 2 days later. It was a Friday evening. A professional process server, not a sheriff's deputy, knocked on my door. He handed me a thick envelope. Inside was a petition for a temporary restraining order, an ex parte order, meaning she had gone to a judge without me being present, and convinced them, with what I could only imagine was a breathtaking work of fiction, that I posed an imminent threat to her. The document was filled with wild, slanderous accusations. It claimed I had threatened her with violence, that I had a history of aggressive behavior, that the survey was a pretext to sabotage community infrastructure, and that she was living in constant fear for her safety. It demanded I stay 500 feet away from her and her property, which effectively included the common area and the street in front of my own house. And it demanded I immediately cease all survey work. The hearing to make the order permanent was set for the following Tuesday morning. She was trying to use the courts as her personal cudgel, to win by default what she could not win by fact. It was a desperate, foolish move, because she was no longer fighting me in the court of neighborhood opinion. She was taking me into my world. The world of evidence, of procedure, of judges and lawyers. The world where her performance would be pitted against my paper trail. The first thing I did was call my son, Robert. Robert is a good son, a man of profound integrity. He is also a judge in the county circuit court. I didn't call him for help or to ask him to intervene. That would be improper, and we both knew it. I called him to hire his old law partner, a man named Tom Bishop, who was the sharpest and most ruthless civil litigator I knew. I explained the situation to Tom over the phone on Saturday morning. I summarized the trench, the certified letter, the lapsed corporate charter, the audio recordings, the treasurer's email, and now, the restraining order. There was a long pause on the other end of the line. "Arthur," Tom finally said, a note of grim amusement in his voice. "This woman isn't just digging a trench, she's handed you a shovel and asked you to bury her with it. Send me everything you have. Every file, every video, every scan. We're not just going to defeat this restraining order, we're going to dismantle her." I spent the rest of the weekend assembling the final package. I organized everything into a chronological, indexed digital file. It was a work of art, a perfect, undeniable narrative of escalating malice and incompetence. On Monday, Tom filed our response with the court, along with a motion to dismiss and a counter-motion for sanctions and legal fees. The stage was set. Tuesday morning arrived, bright and humid. I put on a conservative suit and tie, the same kind of attire I used to wear for county commission meetings. Tom met me at the courthouse. He was carrying a briefcase that I knew contained a laptop and a portable projector. We entered the courtroom assigned for the hearing. It was a small, modern room, smelling faintly of floor wax and stale coffee. Carol was already there, sitting at the plaintiff's table with her lawyer. She was dressed in a demure, navy blue dress, a pearl necklace at her throat. She had a box of tissues on the table in front of her. Theatrics. Her supporters, a handful of equally well-dressed women from the neighborhood, were seated in the gallery behind her, ready to provide a sympathetic audience. Mr. Henderson and Sarah Jenkins were also there, sitting on my side of the aisle, a quiet show of support. Carol gave me a look of triumphant pity, as if I were a strayed dog about to be put down. She had no idea. The bailiff called the room to order. "All rise." The circuit court for the county of Duval, the Honorable Robert Miller presiding. My blood ran cold. Robert, my son. It was his courtroom. Of all the dozens of judges in the circuit, it had been randomly assigned to him. I shot a panicked look at Tom. He looked just as surprised. Out on the dais, Robert walked in, his black robe flowing around him. He sat, looked out over the courtroom, and his eyes met mine. For a fraction of a second, his professional mask slipped. I saw the shock, the surprise, and then, immediately, the steely wall of judicial impartiality slammed back down. He looked at the case file in front of him, then back at me, then at Carol. He cleared his throat. "Good morning," he said, his voice echoing slightly in the quiet room. "Before we begin with case number 2023-CV-1845, Peterson v. Miller, the court must address a matter of procedure." He looked directly at Carol and her lawyer. "I am Judge Robert Miller. The defendant in this case is Arthur Miller. He is my father." A collective gasp went through the gallery. Carol's jaw literally dropped. Her carefully constructed expression of victimhood dissolved into pure, slack-jawed shock. Her lawyer looked like he had been struck by lightning. "Under the judicial canons of ethics," Robert continued, his voice firm and unwavering, "a judge must recuse themselves from any case in which their impartiality might reasonably be questioned, or in which they have a personal relationship with a party. Therefore, I am recusing myself from this case effective immediately. The court clerk will reassign this matter to another judge. We will take a brief recess while that is sorted out." He struck the gavel once. "This court is in recess." And with that he stood up and swept out of the courtroom, leaving a stunned silence in his wake. The beautiful irony was that his absolute adherence to the rules, his immediate and professional recusal, was more damaging to Carol than if he had stayed. It stripped her of her narrative. She had come expecting to perform for a neutral stranger, to spin a tale of a fearsome old man. Instead, the judge was revealed to be the son of her victim, and he had acted with unimpeachable integrity. It made her look foolish. It made her entire petition seem absurd before a single word of testimony had been spoken. Her supporters were whispering among themselves, their confident expressions replaced with confusion. 20 minutes later, A clerk announced the case had been reassigned to Judge Maria Evans and moved to her courtroom down the hall. As we walked, I saw Carol furiously whispering to her lawyer, who looked increasingly uncomfortable. The element of surprise was gone. The momentum had shifted entirely. Judge Evans's courtroom was larger. She was an older, no-nonsense judge, with a reputation for having very little patience for frivolous lawsuits. This was even better. The proceedings began again. Carol's lawyer, trying to regain his footing, called her to the stand. For the next 30 minutes she gave the performance of her life. Her voice trembled, tears welled in her eyes, aided, I suspect, by a discreet dab from a tissue. She painted a picture of me as a reclusive, angry man who had become obsessed with his property line, who had stalked her, who had made her fear for her life. She claimed the survey was a violent act of intimidation. It was a masterpiece of fiction. When she was done, Tom rose for his cross-examination. He was calm, almost gentle. "Mr. Peterson," he began, "you've testified that you are in fear for your life. Is that correct?" "Yes," she whispered, dabbing an eye. "I am terrified." "And this fear is based on the actions of my client, Mr. Arthur Miller?" "Yes. His aggression it's unbearable." "I see." Tom walked back to our table and picked up a single sheet of paper. "I'm showing you what's been marked as Defense Exhibit A. Do you recognize this?" He placed the printout of the signed return receipt for the certified letter in front of her. She glanced at it. "It looks like something from the post office." "It is," Tom said. "It's the receipt for a certified letter my client sent to you 5 days ago. Is that your signature?" She hesitated. I suppose it could be. I get so much mail." Tom then played a video on the large screen facing the judge. It was the footage from my security camera. It showed her signing for the letter, taking it inside, and then, moments later, walking out and dropping the unopened envelope into her recycling bin. "Mr. Peterson," Tom said as the video played. "Is that you in the video?" Carol was silent. Her face had gone pale. The judge leaned forward, her eyes fixed on the screen. "The letter you just threw away without reading," Tom continued, "was a formal, legal cease and desist notice, informing you that you were trespassing and causing damage to my client's property. Does a person who is terrified of someone typically throw away their legal correspondence unopened?" My lawyer told me not to engage," she stammered. "You hadn't spoken to your lawyer yet, had you, Mr. Peterson? Because you didn't hire him until after you were served with our response to this very restraining order. This was 2 days before that." The first crack in her facade appeared. Judge Evans was staring at her, her expression hardening. Tom moved on. "You testified that my client is trying to steal community property. Let's talk about that property." He projected the highlighted plat map onto the screen. "This is the official plat for the Evergreen Terrace subdivision from the county records. Could you please show the court the community property my client is trying to steal?" Carol stared blankly at the map. "It's the corner. Everyone knows it's ours." "Could you show the court the recorded easement that gives the HOA rights over that corner?" Tom asked. It's historic use," she repeated, her voice rising in panic. "Mr. Peterson, are you aware that historic use is not a recognized legal basis for a property claim in this context, without a formal prescriptive easement, which requires decades of open, notorious, and adverse use, and a court order to validate? Are you aware of that?" No." Then Tom brought out the big guns. "Your Honor," he said, addressing the judge, "what Mr. Peterson is not telling you is the real reason for this dispute." He projected the county stormwater permit onto the screen, highlighting the section about the underground drainage pipe. The HOA, under Mr. Peterson's leadership, has failed to maintain the legally required drainage system for this common area. This trench she was illegally digging on my client's property was a negligent, cost-cutting measure to avoid the expense of cleaning a clogged pipe, in direct violation of the original development permit. He let that sink in. Then he played a 1-minute audio clip from Mr. Henderson's thumb drive. Carol's voice filled the courtroom, arrogant and clear. "The covenants are just guidelines. What I say goes. We don't need to spend money on a lawyer." Carol sank back in her chair. The color had drained completely from her face. She looked small and fraudulent. "And finally, Your Honor," Tom said, delivering the killing blow, "the petitioner has come to this court seeking an equitable remedy. But to get equity, one must do equity. The petitioner, Carol Peterson, has been representing herself as the president of the Evergreen Terrace Homeowners Association." He switched the projector's display to the screenshot from the state's Division of Corporations website. The word "inactive" glowed in red next to the HOA's name. "The truth is, Your Honor, the Evergreen Terrace HOA is a defunct corporation. It has no legal authority to act, to levy fines, to enforce covenants, or to file this lawsuit. The petitioner has no more legal standing to be here today than any random person off the street. She has misrepresented herself to my client, to her neighbors, and now to this court. This entire action is a fraud, built on a foundation of negligence and deceit." Tom rested his case. The silence in the courtroom was absolute. Judge Evans slowly took off her reading glasses. She stared at Carol with a look of profound, icy anger. "Mr. Peterson," the judge said, her voice dangerously quiet, "do you have anything to say in response to this?" Carol and her lawyer conferred in frantic whispers. Her lawyer, looking like he wanted the floor to swallow him whole, finally stood up. "Your Honor, in light of new information, my client wishes to withdraw her petition." "Petition withdrawn? Oh no," Judge Evans said, her voice rising. "We are far beyond that. I am dismissing this petition with prejudice, meaning you can never file it again. I am finding that this action was filed frivolously, in bad faith, and for the purpose of harassment. I am granting the defendant's motion for sanctions. You, Mr. Peterson, will personally pay all of Mr. Miller's attorney's fees and the full cost of his land survey. And I am going to have the court clerk forward the transcript of this hearing, particularly the evidence regarding the defunct corporate status and the potential misappropriation of funds, to the state attorney's office for review of possible criminal charges, including perjury." The collapse was total. It wasn't dramatic. Carol didn't scream or cry. She just sat there, her mask of righteous authority completely gone, revealing the hollow, terrified person underneath. She stared into the middle distance, her face utterly blank, as a judge systematically dismantled her life on the public record. She had built her kingdom on a foundation of sand, and the tide of documented reality had just washed it all away. The aftermath was swift and brutal. News of the hearing spread through the neighborhood like wildfire. The transcript, being a public record, was obtained and circulated. The revelation of the inactive corporation and the potential embezzlement was a cataclysm. An emergency meeting of homeowners was called, not by Carol, but by Sarah Jenkins and a few other long-suffering residents. It was held in the community clubhouse, the same room where Carol had held her kangaroo courts for years. This time, she wasn't on the dais. She didn't even show up. The meeting was packed. Sarah, armed with the bank statements and invoices Tom Bishop had subpoenaed, laid out the full extent of the financial mismanagement. It wasn't just Carol's lawyer. It was landscaping contracts given to friends at inflated prices, administrative fees with no explanation. It was a slush fund for her petty kingdom. Mr. Henderson, his voice shaking but clear, stood up and told everyone about the years of bullying and the fabricated fines. Others followed, each with their own story of harassment. It was a dam of resentment breaking. A vote was held. The old board was summarily recalled. A new interim board was elected on the spot, with Sarah as the acting president and Mr. Henderson as the treasurer. Their first official act was to vote to hire a lawyer, not to fight me, but to help them clean up the mess. Their second act was to declare all fines and liens issued by Carol during the previous 2 years null and void, as they had been levied by a defunct corporation with no legal authority. A wave of relief washed over the community. People were laughing, shaking hands. It was like a liberation. The legal consequences for Carol were severe. The state attorney's office did, in fact, open an investigation. She was eventually charged with several counts of grand theft for the embezzlement of HOA funds. Faced with the mountain of evidence Sarah and I had provided, she pled guilty to a lesser charge, was sentenced to 5 years of probation, and was ordered to pay over $60,000 in restitution to the HOA. My legal fees, as ordered by Judge Evans, were paid in full. Her house went on the market a few months later. She moved away, and no one ever heard from her again. The community began to heal. Under Sarah's leadership, the HOA was properly reinstated with the state. The bylaws were rewritten with the help of their new lawyer, adding checks and balances to prevent anyone from ever accumulating that kind of unchecked power again. The clogged drainage pipe was professionally cleaned out. The common area never pooled water again. The trench on my lawn was filled in and resodded by the new HOA's landscaping company, with a personal, handwritten apology from Sarah. My life returned to the quiet I cherished. But it was a different kind of quiet. Before, it was the quiet of solitude. Now, it was the quiet of a peaceful community. Mr. Henderson would stop by to chat when I was in the garden, no longer whispering or looking over his shoulder. The Patels invited me over for a barbecue to celebrate installing their new, fully compliant swing set. I was no longer just the quiet old man on the corner. I was Arthur, the man who had read the rules and calmly, methodically restored order. One afternoon, a few months after it was all over, I was in my office. I looked at the thick manila folder labeled Carol that was still sitting on my desk. It was a monument to a miserable, stressful period of my life. I almost threw it away, but instead, I took out one document, the court order dismissing her restraining order, signed by Judge Evans. I took it, along with the bright orange flag from the surveyor's stake I had saved, to a frame shop. It hangs on my office wall now, next to my engineering degree and my professional license. The orange flag is mounted at the bottom, a splash of defiant color. The order itself, with its cold, legal language, dismissed with prejudice, sanctions awarded, is a testament. It's not a trophy of victory. I take no joy in Carol's ruin. It is simply a reminder that reality is not subject to a vote. The truth is not determined by the loudest voice in the room, but by what is written, what is recorded, and what is real. It's a reminder that order, once disturbed, can be restored, not with anger or aggression, but with patience, with process, and with a deep and abiding respect for the quiet authority of the facts. On paper,